G'day, thanks for joining me again. Today we'll be talking about Batchelor versus the Commissioner of Taxation. It's a 2014 case in the Federal Court of Australia. In this case, the taxpayer had invested $55,000 into a partnership, and that partnership had then contracted with another entity to construct a retirement home. The contracting party, the builder, repudiated that contract, and the partnership sued them and was successfully awarded, by way of a settlement agreement, $6.5 million, essentially as damages. The partnership paid back to the taxpayer $47,927, and so they made a loss on their investment. The interesting thing about this case, though, was that the commissioner had previously published a public ruling called 94/24, and that public ruling was wrong and it was withdrawn. However, when the taxpayer had originally paid the $55,000, they had claimed a deduction under this ruling, and the commissioner had allowed that deduction. The case now is that the taxpayer had received essentially what the taxpayer told the court in the tribunal was that they had received compensation out of that settlement agreement, and the tribunal accepted that as damages and that it was assessable income. In the federal court, however, they were looking at this matter, and they did dress down the tribunal and certainly dress down the representatives of the parties in simply accepting that amount was assessable income and not a return of the deposit or a return of the investment of the taxpayer, meaning that it was capital. The commissioner's argument in this case was under 2020 of the Income Tax Act, which stated that an amount, if you have received as a recruitment for a loss or outgoing, is an assessable recruitment if, and under Section B, you can deduct an amount for the loss or outgoing for the current year, or you have deducted or can deduct an amount for it in an earlier year under any provision of this Act. So the commissioner was saying, because you've previously deducted the amount of $55,000, and that was in error, the commissioner shouldn't have allowed that deduction, then if you subsequently get a recruitment for your loss or outgoing in a later year, then that should be counted as assessable income, and so the two offset. The court found, was referring to quite a key case called Roe, and the principle is essentially that just because something is a deduction in an early year, or just because it's a capital outgoing in an early year, does not mean that any later payment is of the same nature. And Roe is a particularly interesting case that stands for this point. And the federal court essentially said that the tribunal erred in allowing the submissions by the taxpayer that it was damages to simply go through. And the federal court referred it back to the tribunal, stating that the tribunal needed to go and consider further information on this, or go and consider further facts on this present case, and fight for the fact of whether it actually was a return of a deposit or whether it actually was assessable as income. The other side of it was in relation to 2022B, the idea that just because it was deductible before wrongly under the Act, does that mean that the commissioner can now assess it as assessable income regardless of its nature further on? Now, in my reading of it as well, it does say that the deduction needs to come under that the taxpayer, if a taxpayer has made a deduction under any provision of this Act. Now, the taxpayer, the court, I think, and the taxpayer all agree that it was an allowable deduction at the beginning. And so my question is, well, it probably wasn't an allowable deduction under a provision of the Act in the first place, and so 2022B, in my view, probably shouldn't apply. And on that point, the federal court also referred them back to the tribunal to discuss and go and remake the decision. So this particular case isn't full of decisions, but it reinforces the position of Roe, that just because there's a deduction or a capital outgoing in the beginning does not mean that you'll necessarily be able, that it will be characterized as a capital gain or assessable income on the other end. In my view, perhaps, and I'm not sure what the outcome was when it was referred to the tribunal, but perhaps that the taxpayer was allowed a deduction, and then subsequently it was deemed to be a capital reimbursement, in which case it wouldn't be assessable income, and the taxpayer would have the benefit of the Commissioner's mistake. So that's Batchelor versus Commissioner of Taxation. Thanks for joining me.